She filed for divorce first, demanding the house, half my retirement, and spousal support. What she didn't know was that for 6 months before she ever walked into that courthouse, I had been quietly collecting every transfer, every hidden account, every lie she thought she buried deep enough. She sat across from me in that mediation room, completely confident. Her lawyer had no idea what was about to hit them. And neither did she. I'm 38, male, a mid-level software engineer in suburban Ohio. The kind of guy who fixes his own gutters, coaches his nephew's little league team on weekends, and genuinely believed that if you worked hard and stayed loyal, life would be fair to you. Not rich, not flashy, just steady. The kind of man who thought 9 years of marriage meant something permanent. I was wrong about that last part. My wife and I met in our late 20s. She was sharp, ambitious, the kind of woman who walked into a room and immediately figured out who mattered. I admired that about her. I built my whole life around our partnership, the house in a good school district we bought together, the joint savings account we fed every month, the retirement plan I'd been maxing out since I was 26 because I wanted us to retire somewhere warm and unbothered. About 2 years ago, she started a business consulting side project. Small at first, a few clients, some Zoom calls she'd take in the bedroom with the door closed. I supported it. I actually encouraged it. Brought her coffee during late-night calls. Told her I was proud of her. But things started shifting in ways I couldn't immediately name. She stopped asking about my day. She started going to networking events on Thursday nights that ran until midnight. She got a second phone, prepaid, which she explained as for clients who text too much. She started paying for things in cash. Our joint account, which used to hover around $18,000 as a cushion, kept dipping lower. When I brought it up, she'd say she had a big invoice coming. She always had a big invoice coming. The first real crack appeared on a Tuesday in February. I was working from home, and she'd left her laptop open on the kitchen counter while she ran to the gym. I wasn't snooping, I was walking to the coffee maker, but the screen was right there, and what was on it stopped me cold. It was a wire transfer confirmation. $4,200 sent to a joint account I had never seen before. An account with her name on it and the name of a man I'll call her business partner. A guy she'd mentioned maybe 3 times in casual passing as a colleague. I stood there for a long moment. Then I went and got my coffee. I didn't say a word. Because here's the thing about being a software engineer, I think in systems. I think in data. And I had just realized that I had been living inside a system I didn't fully understand yet. So instead of blowing up and giving her a reason to get defensive and careful, I decided to do something she never expected from me. I decided to pay attention. The next 6 months were the strangest of my life. On the surface, everything looked normal. We had dinner together. We watched TV. We went to her cousin's wedding and danced to a slow song, and she put her head on my shoulder, and I held her and thought, you have no idea what I know. Not everything yet, but enough to know I needed more. I created a free cloud storage account under an email address she didn't know existed. Every time I found something, I documented it. I started with what I could access legally. Our joint bank statements, which I downloaded going back 3 years. I cross-referenced withdrawals with dates she claimed to be at client meetings. The pattern was unmistakable. Transfers out, cash withdrawals, payments to a Venmo account I tracked back to her business partner through a mutual contact's public transaction history. I screenshotted everything and uploaded it. Her consulting business had a website, which she'd asked me to build, ironically, 18 months ago. What she didn't know was that I still had admin access to the back-end hosting account. Not to her emails. Not to anything private. But the analytics dashboard showed revenue invoices she'd routed through the business entity. Invoices she had never once mentioned to me or reported accurately in any of our conversations about household finances. The business was making real money. Serious money. And none of it was flowing into our shared life. I consulted an attorney in April. Quietly, a 45-minute phone consultation I took from my car in a grocery store parking lot. He told me plainly, in Ohio, income earned during a marriage is marital property regardless of whose name is on the account. Hiding it is considered dissipation of marital assets and can be treated as fraud on the court during divorce proceedings. He told me to keep gathering information carefully and legally, and to call him when I was ready. I wasn't ready yet, because the real shock came in June. I'd been using our home networks router, which I managed and maintained, to monitor bandwidth usage. Nothing invasive, just traffic logs. Enough to notice that her second phone was connecting to our Wi-Fi at home, which meant I could see what servers it was pinging at what hours. And in June, I noticed the second phone was consistently connecting to a hotel Wi-Fi network, the same hotel every other Thursday between 6 and 11 p.m. I drove by the hotel on a Thursday. Her car was in the lot. So was a car I recognized from 2 years of occasional weekend barbecues. Her business partner's silver Audi. I sat in that parking lot for 10 minutes. Then I drove home. I made dinner. I cleaned the kitchen. I fed the dog. And the next morning, I called my attorney and said, "I'm ready." She filed first, which I had expected. She beat me to the courthouse by 4 days, a fact her lawyer would later use to try to frame her as the one taking decisive action, the one forced into this situation. The narrative she was building was that I was emotionally distant, financially controlling, and that she had built her business independently despite my lack of support. That last part almost made me admire the audacity. Her initial demands in the divorce filing were aggressive. She wanted the house, which had $230,000 in equity. She wanted half of my 401k, which I had been building for over a decade. She wanted spousal support, citing her lower income during the marriage. And she wanted primary decision-making authority on any shared debts. Her attorney sent a letter requesting full financial disclosure within 30 days, as required under Ohio divorce procedure. I disclosed everything, every account, every asset, every statement. I had nothing to hide. Her disclosure came back incomplete. Vague income figures. No documentation for the business entity. No accounting of the joint account she shared with her business partner. Her attorney listed her annual income as approximately $34,000 from consulting, a number so far from reality it might as well have been fiction. My attorney flagged it immediately. He filed a formal discovery request demanding 3 years of business financial records, bank statements, all business contracts, and tax documentation. Her attorney pushed back. They always push back at first. But in the meantime, she was busy with her own strategy. And it was where things got ugly in ways I hadn't fully anticipated. The thing about entitled people is that they don't just fight for what they want. They punish you for making them fight at all. 3 weeks after she filed, I got a call from my HR department. An anonymous complaint had been submitted through an external ethics portal, the kind companies set up for employees to report misconduct. The complaint alleged that I had accessed company systems outside of working hours for personal financial gain, and that I had created a hostile environment for female colleagues. Both completely fabricated, both specific enough to require a formal investigation. I knew immediately where it came from. The investigation took 6 weeks. I cooperated fully, submitted all my system access logs, and provided documented timelines that proved every remote login was for legitimate work purposes. My direct manager, who I'd worked under for 5 years, wrote a letter of support. The complaint was closed as unsubstantiated, but it cost me 6 weeks of stress and 1 quarterly performance review that was delayed because of the open investigation. That was dirty trick number 1. Dirty trick number 2 came through our social circle. She had spent years carefully cultivating friendships with the wives and girlfriends of my closest friends. She was good at it. Warm, present, the kind of person who remembered birthdays and sent check-in texts during hard times. So when she started quietly spreading a version of events in which I had been a cold, withholding husband who never made her feel safe, it landed with people who had no reason to question her. 2 of my longtime friends pulled back. One of them texted me directly and said he needed space to process. I found out through a third friend what she'd been saying. Nothing specific enough to be called defamation, just enough to shift the social terrain under my feet. That one hurt more than the HR complaint, to be honest. Dirty trick number 3 was the joint account. In August, 2 months after she filed, She transferred $12,000 out of our joint savings account into an account I had no access to. When my attorney sent a letter demanding the return of the funds, her attorney responded that she had used the money to pay marital debts and living expenses. A characterization so vague it was basically meaningless. In Ohio, both spouses have equal access to marital assets before a court issues a standing order freezing them. She had moved fast enough to stay technically within legal gray territory. But my attorney documented it carefully, because dissipation of marital assets is taken seriously in Ohio courts, and a judge would eventually see all of it. Through all three of these moves, I did not react publicly. I did not confront her. I did not fire off an angry text at 2 in the morning. I went to work. I walked the dog. I kept building my file. What she didn't know, what she couldn't have known because she'd stopped thinking of me as someone who could outmaneuver her, was that I had already sent 3 months of her bank records, the Venmo transaction history, the business revenue data, and a sworn statement from a forensic accountant to my attorney in July. The forensic accountant, a woman my attorney used regularly in high-asset divorce cases, had gone through every document I'd provided and generated a report estimating my wife's actual business income over the prior 3 years. Her official disclosed number was $34,000 per year. The forensic accountant's documented estimate was just under $190,000 across the full 3-year period. Money that had flowed through the business entity, through the shared account with her business partner, and into her personal accounts, none of which had ever been reported to me or documented in our joint finances. That's not a rounding error. That's a decision. Mediation was scheduled for the 2nd week of September. Ohio law encourages mediation before full litigation, a session where both parties, their attorneys, and a neutral mediator attempt to reach a settlement without going in front of a judge. It's cheaper, faster, and less adversarial than court. Her attorney had pushed for it, probably because they were confident in their position. She had filed first, she had the lower income narrative locked in, and they expected a negotiation where she walked away with the house, half the retirement account, and spousal support payments for the next several years. I let them keep expecting that. The night before mediation, my attorney and I spent 2 hours on the phone going over every document, every piece of evidence, every legal argument. He was methodical and careful, which is exactly what I needed. He told me to stay calm in the room. He told me to let him do the talking. He told me that the goal wasn't to humiliate her. The goal was to demonstrate, clearly and with documentation, that her financial disclosures were fraudulent, and that any settlement based on those disclosures would not survive judicial scrutiny. She has 2 choices tomorrow, he said. She can settle on realistic terms, or she can go in front of a judge with incomplete and inaccurate financial disclosures and explain herself. I slept fine that night. The mediation center was a conference room on the 6th floor of a downtown office building. Beige walls, a long table, a pitcher of water nobody touched. The mediator was a retired family court judge, which was standard practice in Cuyahoga County for cases involving significant assets. She walked in with her attorney looking composed. Good suit. Calm expression. She didn't look at me directly, which told me she'd been coached not to. Her attorney opened by presenting their position. My wife had contributed to the marriage through years of emotional labor and supportive partnership while I had prioritized career advancement. Her business, though growing, remained modest and represented independent effort, and given the length of the marriage and the disparity in stable income, she was entitled to the marital home, an equitable share of retirement assets, and transitional spousal support. He spoke for about 12 minutes. Very polished. Very reasonable sounding. Then my attorney opened his folder. Before we discuss terms, he said, I want to make sure everyone in this room is working from accurate financial information, because the disclosures we received are not accurate. Her attorney leaned forward. Excuse me. My attorney slid a copy of the forensic accountant's report across the table. 1 copy to the mediator. 1 to her attorney. He didn't slide one to her directly. Just let it land in front of the people who needed to see it. This is a forensic accounting analysis of income generated through your client's business entity over 36 months, he said. The documented figure is approximately $187,000. The disclosed figure in these proceedings was $34,000 annually. That's a difference of roughly $85,000 per year. The room was very quiet. Her attorney picked up the report. He flipped through the first few pages. His expression didn't change, but his jaw tightened. "We also have bank records," my attorney continued, "showing transfers from the business entity's joint account, a joint account my client was never informed existed, totaling approximately $64,000 over the same period, transferred into accounts held solely by your client." He placed the bank records on the table. Clean, printed, tabbed with small color-coded flags at the relevant transactions. Additionally, he said, and this was the part one had told him to save for last, "We have documentation indicating that the joint account was held with a third party with whom your client has had an ongoing personal relationship during the marriage. We are not raising this to embarrass anyone. We are raising it because it is directly relevant to the financial arrangements that have been operating outside this marriage, and because it has direct bearing on the credibility of the financial disclosures presented in this proceeding." She made a sound, not quite a word, not quite a breath, something between them. Her attorney asked for a recess immediately. The mediator granted 15 minutes. My attorney and I stepped into the hallway. He poured himself a cup of coffee from a small station near the elevator. I stood by the window and watched the street below. "She didn't know about the forensic accountant," I said. "No," he said. "She didn't. Her attorney didn't either. He may have suspected there were gaps," my attorney said carefully. "He didn't know we had filled them in already." 15 minutes turned into 35. When her attorney finally came back to the doorway, he looked like a man who had just been told something he didn't want to know. The revised opening position from their side was considerably different. The settlement negotiation took the rest of that day, 6 hours with 2 more recesses. By 4 in the afternoon, we had a framework. She would not receive the house. The house would be sold, and the equity would be split based on adjusted contribution calculations that factored in the undisclosed income. Income that had, by my attorney's argument, allowed her to privately fund her own life for 3 years while the household ran on my salary. My attorney's position was that her hidden income represented a unilateral financial decision that diminished the marital estate, and the mediator, that retired family court judge who had seen everything, agreed with the framing. My 401k was divided, but at a fraction of what she had originally demanded. Her attorney had come in seeking 50%. They settled on approximately 22%, calculated based on a formula that accounted for the financial misconduct documented in discovery. Spousal support. Gone entirely. When the mediator reviewed the forensic accounting report, the argument that she was a lower-earning spouse in need of transitional support collapsed. A person who had been generating 6 figures annually for 3 years while claiming $34,000 in disclosure is not a person with a support claim that survives scrutiny. The $12,000 she had pulled from the joint account was treated as an advance against her share of marital assets, reducing her net distribution accordingly. The business entity, and its remaining assets, was evaluated as a marital asset, since it had been seeded and built during the marriage. Her business partner's involvement complicated that calculation, but my attorney had already anticipated it. We weren't claiming ownership of his portion. We were claiming an accounting of the marital portion of revenue that had flowed through their shared structure, and a corresponding adjustment to the settlement. By the time we signed the mediation agreement that evening, she had received a fraction of what she walked in expecting. Not nothing. Ohio law doesn't work that way, and I wasn't trying to destroy her. I was trying to make sure the settlement reflected reality, not a fabricated version designed to benefit her at my expense. When she signed the papers, she didn't look at me. Her attorney said a few professional words to my attorney. The mediator thanked both parties for reaching resolution. Everyone gathered their folders. In the elevator on the way down, her attorney and my attorney were discussing scheduling for the final court filing. She and I stood at opposite ends of the elevator, not speaking. At the lobby, she walked toward the parking garage. I walked toward the street. That was the last time I stood in the same room as her. The final divorce decree was entered by the court 43 days later, incorporating the mediation agreement in full. Ohio courts review mediated agreements before issuing the decree, and our family court judge approved it without modification, which, my attorney explained, was fairly typical when both parties have signed and the agreement reflects documented financial reality. The house sold in the spring for more than we'd paid for it, despite the market. I took my portion, cleared a small debt, and put the rest in savings. My 401k took a hit. 22% is real money. But the account is mine now, and I've been contributing aggressively since the decree. My financial advisor told me if I maintain my current contribution rate, I'll have recovered the full value within 4 years. The HR complaint against me was formally closed and expunged from my record after the investigation concluded. When I mentioned it to my attorney, he noted we had grounds to pursue a defamation claim. I chose not to. Some things cost more than they're worth, and I had already spent enough time on this. The friendships that went cold, some came back around. When the actual picture became clearer, a few people reached out. I don't hold it against them. She was convincing. That was always her talent. Her business, from what I understand through the final asset accounting, lost its primary structure when the partnership arrangements had to be disclosed to the court. Her business partner was deposed briefly for the financial review. I don't know what happened between them after that, and I genuinely don't care. What I think about now, when I think about any of it, is not the mediation room or the bank records or the forensic accountant's report. What I think about is the version of myself that stood in the kitchen on that Tuesday in February, looking at a wire transfer on someone else's laptop screen, and decided to say nothing. Decided to think first. That version of me made every difference. I'm not a dramatic person. I don't have a flair for confrontation. But I learned that patience, real patience, the kind where you build something careful and complete before you move, is its own kind of power. And that people who assume you're not paying attention are always surprised when you prove them wrong. The dog is still with me. He sleeps at the foot of my bed now. He doesn't seem to miss anyone. Neither do I. All right, now I want to hear from you. Drop in the comments. Did she deserve everything that happened in that room? Or did he go too far? And if you were sitting across that table, would you have stayed quiet for 6 months like he did? Or would you have blown up way sooner? Be honest, because the comments on this one are going to be wild.